Good afternoon, Your Honor. Mark Dorso for the State of Connecticut.
Good afternoon, Your Honor. Tatiana Messina for the State of Connecticut.
Good afternoon, Your Honor. Kevin Smith for the defendant. Raul Valle is at my side.
All right, so counsel, as you are aware, we have received a note from the jury which indicates that the jury has reached a partial verdict. And when I say partial verdict, in summarizing the note, which does indicate to some extent the deliberative process, it appears that the jury has reached a verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at both counts 2 and 3, and assault in the second degree intentional at count 4. At this time, the court's intention would be to accept the partial verdict and declare a mistrial on any lesser included charges upon which the jury is unable to reach a verdict. I will note that the note additionally indicates that after lengthy deliberations, the jury is hopelessly deadlocked on the other charges. So I would give each counsel an opportunity to be heard at this time. I'll start.
Thank you, Your Honor. The State would be requesting that the court now at this moment give a Chip Smith charge to the jury. They've been out 2.5 days now, I guess, a little over 11 or 12 hours. There were 25 witnesses that were called in this case. There was a mountain of evidence that needed to be reviewed. And we went from hopelessly deadlocked after an hour and 45 minutes to now having a partial verdict. So I would submit that perhaps there'd be, if the court was inclined to give that Chip Smith charge, that they could go back and maybe come to a decision on the charges for which they are deadlocked on.
Thank you, Your Honor. Your Honor, the defense would object to a Chip Smith at this point. The court has already twice sent them back with essentially a Chip Smith light sort of instruction on the basis of Feliciano. And I think that the jury has indicated now on a number of occasions that they are rather hopelessly deadlocked as to those charges which they still cannot come to any resolution on. My understanding of the note is simply that giving them another charge is not going to change that, and so we would object.
So in response to the request for the Chip Smith, which is basically another attempt at the court to ask the jury to continue its deliberations, the court is hereby denying that request on behalf of the state. In keeping with Feliciano, this court has not once, but on 2 occasions provided a chunkier or a wider Feliciano charge. On day 1 of the jury having this case, the court received a note that it was hopelessly deadlocked on the murder count. The court, upon agreement with counsel at that point in time, instructed the jury to continue deliberating. At that time, I instructed the jury to review the evidence, discuss and consider the opinions of other jurors, to explain the views and listen to the views of other jurors, including the majority, to listen to what the minority had to say, as well as the minority to listen to what the majority had to say. Subsequently, on day 2, after about 5 hours of continued deliberations having passed, the jury did send a second note indicating the following: that the jury was deadlocked on murder at count 1, indicating that the jury had reached a verdict at count 2 and count 3 as to assault in the first degree, deadlocked as to lesser included charges, and with respect to the last count, count 4, again indicating a possible verdict as to assault in the second degree, intentional, but deadlocked as to the first lesser included charge as well. Once again, that note was discussed with counsel. Once again, upon agreement by counsel, the court extended to the jury another Feliciano type of charge, which included more language than the standard go back and deliberate charge. The court once again looked at the jury and instructed the jury to continue deliberating, to review the evidence, see if any evidence was overlooked, make sure that no evidence was misunderstood, and to explain the views and listen to the views of all other jurors. The jurors did continue their deliberations, and they did review some evidence, which we came back on the record to produce for them. So at this point in time, the court is not going to go ahead and give them a third instruction to continue the deliberations. The court is going to accept the verdict.
And just one more thing, if I may put on the record, Your Honor, with regards to the court's intent on declaring a mistrial on the remaining charges that do exist, the state's intent would be, if that were the case, that we would be filing an amended information to include those charges.
All right, well, I don't know when you would be filing that amended information, but we're going to accept the verdict before any amended information is filed.
Thank you.
Nothing, Your Honor. Thank you.
All right, we have a verdict. We're going to take that verdict. Does anyone else have anything else to say?
Nothing from the state, Your Honor.
Not from the defense.
All right, at this point, we'll bring the jury in, please.
The rest of you, sir? The rest of the jury. Oh, you're not? Whoever you guys.
All right, it appears as though all of our juror members are present. I would seek the counsel's stipulation as such before I begin.
The state will stipulate to the presence of the jury, Your Honor.
Defense stipulates, Your Honor.
So I first would like to inquire as to the foreperson. Would the foreperson please just stand? Thank you. All right, so Mr. Foreperson, I did receive a note that was signed by you, and it was time-stamped as well. The note indicates to the court that the jury, although unable to unanimously agree on some charges, has unanimously agreed as to a verdict on murder at count 1 and manslaughter in the first degree intentional at count 1. Also, as to counts 2 and 3, the jury has a verdict on assault in the first degree intentional. And then lastly, as to count 4, the jury has reached a verdict as to assault in the second degree intentional. Is that correct?
Yes, Your Honor.
All right. So at this point in time, I would ask you to be seated. All right, the court at this point in time is going to move forward with the verdict that you do have relative to the counts and the charges that you have relayed in the note and that you have just confirmed on the record. So Madam Clerk is going to be providing to you additional instruction as she accepts that partial verdict, okay? Thank you. Come on.
Ladies and gentlemen of the jury, as your names are called, please indicate your presence by answering here, rise, and remain standing. Identify himself for the record.
Yes, here. James Stone.
Thank you.
All but the foreperson may be seated. Mr. Foreperson, in the case of State of Connecticut versus Raul Valle, has the jury agreed upon a unanimous verdict as to murder at count 1, manslaughter in the first degree intentional at count 1, assault in the first degree intentional at counts 2 and 3, and assault in the second degree intentional at count 4?
Yes, we have.
Will the defendant, Raul Valle, please rise and face the jury? Do you find the defendant guilty or not guilty?
Not guilty.
We have to go through the in docket number 8 and
Oh, it's not on here. Sorry. In docket number AAN CR 22-0189-418T, count 1 of the substitute information charges the defendant, Raul Valle, with the crime of murder in violation of section 53A-54A, paren A of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of section 53A-55, paren A, paren 1 of the Connecticut General Statutes, do you find the defendant guilty or not guilty?
Not guilty.
Okay, Madam Clerk, please pause. All right, I'm going to direct the court's inquiry to the foreperson at this time. Mr. Foreperson, your note indicated, and that's Exhibit 10, Court Exhibit 10, your note indicated that the jury, after lengthy deliberations, was hopelessly deadlocked on manslaughter in the first degree reckless in violation of Connecticut General Statutes 53A, 55A3 as a lesser included offense at count 1. Is that correct?
Yes, Your Honor.
All right, so you were unable to reach a unanimous verdict as to that particular charge, is that correct?
That's correct.
Madam Clerk, please continue on with count 2.
Count 2 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, again, the note that was sent to the court, provided to the court and marked, indicates to the court that after lengthy deliberations, the jury is hopelessly deadlocked on the charge of assault in the first degree reckless in violation of 53A, 59A3 as a lesser included offense at count 2. Is that correct?
That's correct.
All right, so you were unable to reach a unanimous verdict regarding that particular charge as a lesser included offense. That is correct.
That's correct, Your Honor.
Thank you. Madam Clerk, please continue on to count 3.
Count 3 of the substitute information charges the defendant with the crime of assault in the first degree intentional in violation of section 53A-59, paren A, paren 1 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Again, Mr. Foreperson, Exhibit 10, Court Exhibit 10, your note to the court indicates that with respect to assault in the first degree reckless under count 3, after lengthy deliberations, the jury is hopelessly deadlocked on that charge of a lesser included offense. Is that correct?
Yes, it is.
So you were unable to reach a unanimous decision as to assault in the first degree reckless in violation of Connecticut General Statutes 53A, 59A3 as a lesser included offense under count 3. Is that correct?
Yes, Your Honor.
Thank you. Madam Clerk, please proceed to count 4.
Count 4 of the substitute information charges the defendant with the crime of assault in the second degree intentional in violation of section 53A-60, paren A, paren 2 of the Connecticut General Statutes. Do you find the defendant guilty or not guilty?
Not guilty.
Madam Clerk, please pause. Mr. Foreperson, Court Exhibit 10, the note that was forwarded to the court indicates that at count 4 as to assault in the second degree reckless, after lengthy deliberations, the jury was hopelessly deadlocked on the above charge. Is that correct?
That's correct.
All right, so is it correct that the jury was unable to reach a unanimous decision as to assault the second degree reckless in violation of Connecticut General Statutes, Section 53A-60A3 at count 4.
Yes, Your Honor.
Thank you. 130.
Your Honor, may the verdict be accepted and recorded?
Yes, the verdict shall be accepted and recorded.
Ladies and gentlemen of the jury, listen to your verdict as it is accepted and recorded. As to the first count of the substitute information charging the defendant with the crime of murder in violation of Section 53A-54A of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to count 1 of the substitute information charging the defendant with the lesser included offense of manslaughter in the first degree intentional in violation of Section 53A-55 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.
As to the second count of the substitute information charging the defendant with the crime of assault in the first degree intentional in violation of Section 53A-59 of the Connecticut General Statutes, you say the defendant is not guilty. Is that your verdict?
Yes.